Back in September, New Look entered into a company voluntary arrangement to put over 400 stores on rents based on shop turnover up to a maximum of 12%. The proposal was approved by its creditors, but as you can imagine, some of the landlords weren't too happy with the decreased rents. In this video, we'll look at how this proposal worked, what a CVA is, and the rejection of the landlord's latest legal challenge that we saw this week. So as we said, in September, New Look asked its landlords to agree to a rent based on shop turnovers to manage the challenges brought by the pandemic. The company also said that it would go bust if the Company Voluntary Arrangement, or CVA, was not approved. As many retailers, New Look was hit hard in the pandemic because its sales are heavily reliant on large stores, which are concentrated in market towns, and also only about 20% of its sales are made online. However, New Look's proposal was a bit controversial because it was the second time in as many years that the company had asked landlords to cut rents. A previous CVA in 2018, which is now superseded by this one, resulted in the closure of more than 130 shops and rent reductions at many more. So seeing this situation right before their eyes, a group of 4 landlords, including Land Securities and British Land, plus the new owners of Manchester's giant Trafford Centre, were unhappy and they decided to bring a legal challenge. But before we dive into more detail, let's quickly touch on what a CVA actually is. So a CVA is a form of UK insolvency process which is used by distressed businesses to reduce liabilities over a period of time. It is proposed by a company to its creditors and shareholders, who must then consider the proposal and vote on it at a creditors' meeting. If the vote at the meeting achieves a 75% majority of creditors by value in favour, then the CVA is approved. Importantly, creditors are bound by a CVA even if they did not vote in favour of it, but they can challenge it within a short 28-day window after approval if they think there has been unfair prejudice or material irregularity. In New Look's case, almost 2/5 of landlords voted against the proposal, but the CVA still proceeded because other unsecured creditors, such as suppliers, voted in favour. So let's go back to New Look's case and look at what the landlords' argument were in their latest legal challenge. The first argument brought by the landlords was that they were unfairly prejudiced by the CVA. They said the proposal was obtained with votes of creditors that were either not affected or treated more favourably. Their second point was that the New Look CVA was not a CVA, and they specifically looked at different treatments between groups of creditors and the unfair turnover-based rent. And thirdly, they claimed there were irregularities in the calculation of voting rights and also in the disclosure of relevant information. The judge hearing this case rejected their arguments on all counts and stated in particular that the fact that landlords could be outvoted by other creditors did not mean that their interests were being unfairly prejudiced. The court also added that the unfair argument was reduced by the fact that landlords were offered the option to terminate their leases and take their properties back, or stay with the CVA terms. Back in September, Melanie Leach, the chief executive of the British Property Federation, said that CVAs were wrongfully being used as a weapon by businesses to rip up leases permanently and that their misuse must stop. But in terms of the effect of this decision, both in the short term and in the long term, it will most likely create a precedent which is great for struggling retailers and maybe also a bit for landlords. As you can imagine, this judgment is a relief for struggling retailers because if the challenge had gone the other way and been successful, it would have placed limits on the aggressive use of CVAs. However, it's important to note that without the CVA, New Look would have probably faced an administration in which its assets would be realised for its secured creditors, leaving nothing for unsecured creditors other than the prescribed part. And this is a point that New Look mentioned in its case by saying that the CVA allows landlords to achieve a better result than they could have expected to receive if it had not been approved. However, landlords will probably see this as a disastrous judgment because it suggests, in a way, that retailers can now vary the terms of their leases without too much punishment provided they're successful in their CVA. Another key learning point from this case is that it's very hard to challenge a CVA. In September 2019, a challenge funded by Sports Direct, who claimed that a CVA brought by Debenhams treated them less favourably than other unsecured creditors, was also rejected. The Debenhams CVA allowed the store to close 22 stores and cut rents on 100 more. And thirdly, this story also highlights the rise of turnover-based rent. A survey of UK landlords by a property consultancy firm in May found that 40% would now be more likely to factor turnover, footfall, or online sales into lease agreements. And overall, this means that landlords are now going to have to accept more risk sharing in terms of taking on turnover to render lease affordable for tenants and ensure their returns. But would you incorporate online sales in this calculation? Landlords have argued that having a store in a popular area like London Soho would deliver great brand awareness, and many customers may buy products via their online store instead. But how do you record that? This is undoubtedly a very interesting story which we feel has gone a bit under the radar, but it shows exactly how retailers adapted to manage challenges brought by the pandemic via this CVA tool. We shall see how further cases in this area play out, but this story will undoubtedly set an important precedent for future decisions that will support retailers' positions.